Blank. I'm the director of the International Humanitarian Law Clinic here at Emory, and I'm very happy to bring to you this afternoon a panel on the law of war and cyber war. I don't remember the formal name of the panel now. But we have a distinguished group of experts here. I'm just going to give you a really quick introduction to each of them, and what we're going to do is have a conversation. Re-Conceptualizing international law frameworks in response to the threat of cyber war. Thank you. So on my immediate right here, I have Colonel Gary Brown, who is a staff judge advocate for Cybercom up in Washington. And he provides advice regarding the law of war and other issues there. And before that, he was senior legal advisor to Air Component Commander in Southeast Asia, among a variety of other postings. To his right is Eric Jensen, who's professor of law at Brigham Young University. And before that was at Fordham Law for a couple of years, and before that was a judge advocate in the U.S. Army, where, among other postings, he served as chief of the Army's International Law Branch and deputy legal advisor for Task Force Baghdad. To his right is Professor Catherine Locianti, who is executive director of the Institute for Law, Science, and Global Security at Georgetown University. She teaches a variety of courses on intelligence law, national security law, international law. She's the director of a cybersecurity project and was recently counsel to the President's Foreign Intelligence Advisory Board. And last but not least, on the end is Michael Schmidt, who is chairman of the International Law Department at the United States Naval War College. Came there recently from being chair of public international law at Durham University in the United Kingdom, and was dean of the George C. Marshall European Center for Security Studies in Germany. And before that was a judge advocate in the United States Air Force, specializing in operational and international law. So what we're going to do today is, rather than some set presentations, as promised.
Except for Mike, right?
Except for Mike, you have a PowerPoint, right? Instead of set presentations, I thought it would be great if we could really have a back and forth conversation here about a whole range of issues that come up, in a lot of which we've already talked about a little bit here in the keynote, that arise when dealing with questions of international law, cyber war, cyber attacks, and so on. So what I'm going to do is start each of you off with a question or two and let you just kind of go at that one for a couple of minutes, and then we'll do some back and forth, and then at some point open it up to audience questions. So Mike, actually, I'd like to go to you first. If you can talk to us all a little bit about the different international law frameworks that apply here, and how cyber war strains them, if it strains them in some way, and what we need to be thinking about in terms of how we think about international law, both regarding the use of force and regarding the application of the law of armed conflict when we're talking about cyber.
Well, I guess my response you should gather from my intervention and the keynote speaker's presentation. My big concern is that there's extraordinary confusion about the various legal regimes that apply to cyber operations. So maybe, Lori, to answer your question, I'll just mention the four biggies that are often confused. The first is the term use of force. The term use of force is derived from the jus ad bellum. That's the body of law that governs when it is a state may resort to force as an instrument of its national policy. When can a state do self-defense? When can a state do humanitarian intervention? When can a state engage in cyber operations pursuant to Chapter 7 of the UN Charter? This concept of the use of force is found in the Charter, Article 2.4 of the Charter. And basically it says that one state may not use force against another state. This is a prohibition. In other words, the legal significance of the term use of force is, if you do a use of force, then it's a violation of international law unless there's a specific exception to that use of force or to that prohibition. The most common one, which I'll talk about in just a moment, is armed attack. So in the cyber context, the question is, what's a use of force? Well, as our keynote speaker absolutely correctly identified, in the cyber context, this is perhaps the toughest question to answer. And the reason is although a layperson would know what use of force means, and although an introductory lawyer might be able to surmise what a use of force means, that's not what it means. And we know this because of the charter drafting history. Because when they were drafting the charter, they specifically asked the question, well, we've got this provision, so like, what's it mean? What's this use of force term? And it was specifically agreed in San Francisco in 1945 that it did not mean armed force. It did not mean armed force. Now, they also said it also doesn't mean certain other things like economic or political warfare, but it does not necessarily, it is not to be equated with armed force. And so this, by the way, this was a conclusion that was affirmed by the International Court of Justice in a very famous case, Nicaragua. In any event, the question then becomes, okay, so if it's not necessarily armed force, what about the cyber context? If I fire electrons at something and stuff doesn't break and people aren't injured, have I violated the prohibition on the use of force? And again, in a wonderful presentation a few moments ago, correctly, the law fails to answer this question. There's a project that is currently ongoing to draft a manual on the international law applicable to cyber warfare, and Eric and Gary are members of this project, and we've been struggling with this question as well. What I think the consensus is now is that when answering the use of force, what you ought to be trying to do is trying to anticipate how the international community is going to characterize a particular cyber action. And so what you really want to do, in the absence of any clear guidance in the law, what you really want to try to do is try to predict that reaction. In other words, if I do something, will people style it as a use of force? Or if someone does something to me, can I reasonably make the pitch that they just did a use of force against me and there's no excuse for that force in the law? And so the correct response, I believe, is to look at a number of factors. Different people have come up with different factors. Our group has agreed upon 7 that derive from an article I wrote a long, long time ago in the Columbia Journal of Transnational Law, and they include factors like severity. Clearly, if you're killing people, that's grave enough to constitute a use of force. They include factors like measurability. Can you ascertain how much harm is going to, can you quantify the harm that is caused? It includes factors like invasiveness. To what extent did I have to penetrate a system in order to achieve the effect I sought? But the bottom line is, use of force is about whether you, another state, violated the prohibition on the use of force. It's about whether you're a lawbreaker. This should not be confused with the term armed attack, which appears in Article 51 of the Charter, also jus ad bellum. And basically what Article 51 says is that you may use force, whatever that means, you may use force if you are the victim of an armed attack. An armed attack is a legal term of art. It's not a lay term, it's a legal term of art. Again, if we look at the history of the Charter, what we can surmise is that the framers, the drafters rather, did not want use of force and armed attack to be the same thing. That's why they used different terms. Because the Charter is about a presumption against against forceful things. What the Charter wants to do is make it easy to violate the norms, so you won't do it, and make it hard for you to react to the norm so that the international community can handle that instead of you. So armed attack. What does it mean? It's clearly a much higher standard. Everyone agrees on this. This was something which was accepted by the International Court of Justice in a number of cases, including the Nicaragua case. And most people would agree that an armed attack under 51, the act that allows you to respond forcefully, an armed attack is something which damages property, injures people in a relatively severe way. So if you're the victim of a use of force, but that use of force doesn't rise to the level of an armed attack, you may not use force in response. So all these problems present themselves in the cyber context. If I'm shooting electrons, when do I cross the armed attack threshold such that they can shoot back at me? Now, break. That's the jus ad bellum. Please put that aside and don't put the two sheets of paper anywhere near each other. Because I'm going to talk about a body of law that has absolutely nothing whatsoever to do with jus ad bellum. And that's the jus in bello. That's international humanitarian law. In international humanitarian law, there are two terms you need to know about. The first one is armed conflict. Again, it's not a lay descriptor, it's a legal term of art. Armed conflict comes in two forms. It's not defined in humanitarian law, but the two subgroups are international armed conflict, non-international armed conflict. International armed conflict is state on state. Okay? Non-international armed conflict involves a non-state actor, an organized armed group, against a state, or an organized armed group against an organized armed group. Clearly, if cyber is occurring during an ongoing armed conflict, all the rules of the law of armed conflict, of humanitarian law, all those rules apply to the cyber operation. So if it's occurring during state A against state B, the law of international armed conflict will apply not only to dropping bombs from aircraft or naval gunfire, since I'm from the Naval War College, but also to cyber operations. And if you're in Afghanistan today, you are in a non-international armed conflict. If cyber is conducted, the law of non-international armed conflict will apply. This is uncontroversial in the extreme. The controversial issue is, yeah, but can you have an armed conflict if you just have cyber? If state A fires cyber at state B, is that an international armed conflict? Or if a non-state actor, a terrorist group, Al-Qaeda, whoever, fires cyber at a state, is that a non-international armed conflict? I think, again, the answer is, has Dick Jackson from the Army correctly hinted at earlier on, it has to do with effects. If you are causing effects that would be seen in a kinetic environment has an armed conflict, then you're there. And what does that mean? It usually means harming people, harming things. Okay? In the non-international armed conflict, there are some problems with regard to cyber, because to have a non-international armed conflict, you must meet two criteria to distinguish it from, say, riots or law enforcement problems. And the two criteria are organization and intensity. Organization, the huge question is, can you have an organized armed group that's entirely virtual? Can the 10 of us meet online, have fake names, and conduct attacks against Canada? Are we an organized armed group, even though we don't even know who we are? I believe the answer is yes, if our actions are coordinated. But this is simply my view. It's very controversial, because many people say the organized armed group must have a means of enforcing the law. And how do I enforce the law against this Australian? If you've been to Australia, you know they're very lawless, okay? How in the world can I enforce the law against this Australian if I don't know who she is? That's the first problem. The second problem is intensity. Intensity requires a level of hostilities that are protracted in nature. There's some famous court decisions on this. The most notable is Tadic. When is a cyber conflict protracted? If I fire electrons and then don't fire them for another week, is that a protracted conflict because it occurs instantaneously? Is it the effects which render it protracted? This is very, very uncertain in the law. I personally believe it would be very, very difficult to rise to the level of non-international armed conflict in the cyber environment, only cyber environment. So if you have a group which is launching cyber at a state, I don't think you're usually going to get to the place where it's non-international armed conflict, and therefore the law of armed conflict will not apply, but instead human rights law and domestic law. And then finally, very quickly, the last word is attack that you must know. Attack, again, is not a lay term. It is a legal term. It is defined in Article 49 to the Additional Protocol 1 to the Geneva Conventions, has acts of violence, whether in offense or defense. And this is why Dick Jackson asked his very good question early on. Because the law of armed conflict is framed in terms of attack, don't attack civilians. Don't attack civilian objects. Don't attack medical stuff. Don't attack dams, dikes, nuclear, electrical generating stations. Don't attack, don't attack, don't attack. So what's an attack? Well, if it's an act of violence, cyber is not an act of violence. It's not a violence. It's not like I strike Catherine here. That's not violent. However, many people, I'm one of them, believe that an attack in the cyber context is something which, again, causes physical harm or injury, or I would go so far has permanent interference with functionality of a system. Then it's attack, then it's forbidden. Why is that important? Because if it's not an attack, it's not forbidden. There's a long-standing debate between myself and my very, very dear friend Knut Dorman, a brilliant lawyer at the ICRC, the legal, head of the legal division there. Knut takes the position that an attack depends, and I'm paraphrasing, so forgive me, Knut. I'm sure he'll be watching this over and over again. I'm paraphrasing, but for him, it's the target of the operation that matters, and if it's a civilian, it's forbidden. I say it's not the target, but rather the effect, and so therefore it's entirely permissible to conduct cyber operations against civilians and other protected objects and so forth, so long as it doesn't rise to the level of an attack. This is very controversial. It's very unsettled in the law. The jury's out. It's 50-50. So, Lori, in answer to your question, long answer to a simple question, my plea is be precise in your legal thinking. Don't be sloppy. Use of force is an ad bellum concept that answers the question of how are you possibly in violation of international law by resorting to force. Armed attack, the next term, is also ad bellum. It's Article 51, and it answers the question of what can you do in response to a cyber operation that rises to the level of an armed attack. Armed conflict is all about, do you then turn to this book? Because if you're not in an armed conflict, forget it. Human rights law applies. Period, stop, end of discussion. Okay? You have to get an armed conflict before the law of war applies. And then finally, what's an attack? An attack in the legal sense. Because attack, the term, tells you what you can and cannot do on the battlefield.
I'm going to turn to Gary next. And another question that cyber naturally brings up has to do with sovereignty. And as we know, sovereignty is sort of an essential cornerstone of the international system, and the development of international law on so many levels, not just law of war, is how we, and I think until you think about cyber stuff, it's not that hard to figure out what sovereignty is. It's my space, right? You think of the state in international theory as a black box. This is mine, that's outside my borders. What happens when we bring cyber into this? What does it do to sovereignty? Do we think about it differently? And if sovereignty changes if cyber changes the relevance of sovereignty, would that bleed back into the non-cyber world? Are we going to see a change in the notion of sovereignty and how we understand it?
Before I speak, I guess I should say, if there's any resemblance between my comments and U.S. policy, it's coincidental. I'm not sure if there will be or not, but there are people here that will tell me that I'm wrong, I'm sure, if I tried to represent U.S. policy, so I don't. And also, I guess, sort of in a rebuttal to Mike's comments, I guess this is my plea for muddy thinking, because frankly, when we work with policymakers and with the folks who are trying to sort this out at the operational level, we're generally not dealing with guys nearly as smart as Mike Schmidt or guys nearly as experienced as he is in international law. So the most common question we get, and you've probably all seen this, is not, was it use of force, was it an armed attack, was it an attack at all? Was it an act of war? And, more a political comment than anything else. So those are the things we deal with. And I will talk a little about a couple of views on sovereignty, but I also want to talk about cyber muddies the waters in everything. And I think the more you look at it, at least this has been the case with me, the more you look at it, the more it seems to muddy the waters. And just as one brief example, we sort of cavalierly talk about offensive cyber operations. And when we talk about kinetic military operations, more traditional military activities, we generally don't have a whole lot of trouble deciding what's offense, and we don't really even talk about defense. We talk about offensive actions, and we have execute orders in the U.S. military that give us the authority to engage in offensive activities. But when we talk about cyber, what exactly is an offensive act in cyber? It's not typically killing people or breaking things, at least the way people seem to be thinking about it. It's merely things like looking in another person's computer or accessing data that maybe they would prefer you not access and things like that. Now, understanding that there's a separate category for espionage, that's another issue that I think we'll talk about a little bit later. But all these things that are very minor will be considered very minor activities. Maybe, for instance, a denial of service attack. We see those all the time in the commercial world, or hackers just messing around, taking down some U.S. government websites, for instance. Is that denial of service, would that be, if the military did it, would that be considered an offensive military activity, akin to an invasion or launching airplanes to drop bombs on another country? To me, it's interesting that those very basic questions become very difficult to answer in cyber. To talk just a little bit about sovereignty, I do think there's a difference between a nation's cyber sovereignty and what we think of as traditional sovereignty. And it's different because, partly because cyber is just really hard to figure out. The way the internet works, with algorithms deciding where packetized information flows across the globe to be reassembled at the destination into a comprehensible whole, we are, by plugging into the internet, by plugging equipment into the internet, by becoming part of this incredible engine of commerce and growth and intellectual value, nations, it seems to me, are ceding some of their sovereignty by saying, look, I own this stuff, whether it's corporations in my company or even state-owned equipment. I'm plugging into this great thing that I'm going to derive all kinds of value from. But in doing so, I recognize that people are going to be flowing things across my equipment that I may not care for. Some of those things would be unlawful in the United States. Lots of criminal information flows, packetized information flows, illegal images flow, terrorist information flows, enemy intelligence might flow across, I'm sure it does, flow across the internet, across things in the United States. We've ceded some portion of our sovereignty. So unlike with airspace, for instance, where we haven't ceded, we say, no, if you're going to fly airplanes across, you have to have an agreement to fly them across our airspace. So we've done something different. Now, it's easy enough to say, well, if it's just traversing across, that's okay, but if it's having an effect, which is one of the things that Mike talks about, which is perhaps will develop into a standard that we can use, but I think it does get muddy when we start talking about the way the equipment on the internet works. Sometimes data might be stored on equipment that's located on your sovereign territory for some period of time before it's transmitted on, because of just the way the internet works. So once we've said it can be stored for some period of time, then we're just talking about how long that period of time can be before it actually is on your territory, and it might be offensive to you. So again, you have to say, well, maybe there's a little difference in cyber sovereignty than something else. And then we get into, well, the standard that has been suggested is, well, does it have an effect in your territory? The problem with that might be what constitutes an effect, because if manipulating bits is an effect, well, of course, the bits are manipulated as the data passes across your routers and servers across your territory. So you're already manipulating bits on there. So if it's something that has an effect in the physical world, that might be a standard that we could live with, but that's a very difficult standard. And in effect, I think merely, if we were going to conclude that merely manipulating digits on a server would constitute an effect that would impact sovereignty, then we'd also have to start taking a look at telephone calls into the country, because of course we're mostly using voice over IP when we call, and we can certainly have effects in the physical world when we call somebody and pretend to be somebody else maybe and say your appointments change times and somebody doesn't show up at an appointment. That's an effect in the physical world. I don't think generally that would qualify as a violation of sovereignty of a country to make a telephone call like that. So adding the digital layer onto things just makes it that much more difficult than it is typically. So that's a thought about sovereignty.
Catherine, what about the overarching concept of rules and norms that what we need to think about with cyber? Are we just taking an existing framework and using it? Are we picking and choosing from within rules and norms? And what sort of principles underlie these different rules and norms? I mean, we've already talked about jus ad bellum and jus in bello. What other legal frameworks? And as we were discussing earlier, is this a question of analogy, or is this a question of actual straightforward application of the law?
So I think, and this goes back away even into the 90s when the topic was being discussed. In the 90s, there was, those that were discussing the topic were often challenged, and the question was, does international law apply, period? Mostly focused on armed conflict, but also jus ad bellum. And I remember when I would be asked these questions, for me, it was a no-brainer, and I think after reading what Mike was writing in the late 90s, I came out with a piece on the norm of non-intervention, applying the norm of non-intervention under customary international law to cyber operations. So whether we think of it by analogy, I don't think, so think about counterterrorism where we have more experience. There were some people who said, oh, we're in a new state of affairs where non-state actors have power which we didn't envision before, and some people advocated that we needed a whole new set of rules, or that the current rules somehow didn't apply to non-state actors, such as terrorists. I think we can learn from lessons there and see how troublesome that can be, to scrap a whole area of law, but rather, and some have advocated on the counterterrorism to redraft the Geneva Conventions, right, to explicitly deal with terrorists. I don't think that we need to redraft and open at one. It may be impossible to get consensus on doing that. It may bring into the discussion more problems if we do that. But by analogy, apply the laws that we have for a long time abided by, jus ad bellum, jus in bello, to cyberspace. So I think, but be precise in terms of what these words meant then and whether it's applicable, and identify there will be areas where it'll be more difficult to draw analogies in. The particular area with jus in bello, with proportionality and discrimination is more difficult because of the nature of operations in cyberspace. To build on what Mike said, in jus ad bellum, I would also add, the question that there's a violation of sovereignty at one level. Then there are uses of force that might not be in violation of Article 2.4. I've often discussed with my students that there was a particular type of use of force that Article 2.4 talked about. It was the threat or use of force against the political independence or sovereign integrity of a state. So there are arguments that you could take certain actions which would even fall below the level of 2.4. And as Mike appropriately talked about, the higher threshold of what equals an armed attack. So I think the effects approach is the best approach to look at the effects of what you're doing in cyberspace. And then by analogy, because the effects approach has been used in in counterterrorism as well. I think one area where Mike maybe wants to throw a punch my way, but we may disagree, is on the target issue. I think because of the critical infrastructure and the importance of some of our private sectors to be protected, and thinking about what equals an attack, I do think there is some value to talking with allies, and more importantly, our non-traditional allies, to come to some kind of agreement where there may be certain targets that the mere targeting of them, and I don't want to use the word attack, but the fact that you would even go after, for instance, a financial sector would be agreed to be equivalent to an attack. I think that's probably the best area of international agreement that we could build upon. I don't think we'll get a multilateral international treaty like an arms control treaty in this area, but I do think there are enough countries concerned about their critical infrastructure that we may be able to get some agreement, but it does come to it has to come to an agreement as to certain targets could automatically be considered to equal an attack if you conduct a cyber operation against that target. And I think that's important for the U.S. because much of our national security infrastructure is based on private sector and our critical infrastructures. Another area of difficulty is espionage versus attack. And under international law, these are separate, and they have to be, under cyber operations, they have to be analyzed separately as well. You know, I was referring to the DNI who just came out today. Someone sent me the DNI, the Director of National Intelligence Threat Assessment, and he talks about cyber as one category of threats. And he identified that the biggest problems in terms of the cyber threats for the U.S. is identifying past and present security breaches, so attributing them as well, and then accurately distinguishing between cyber espionage intrusions and potentially disruptive cyber attacks. And the reason why there's a distinction is because in the law, there's a distinction. Cyber attacks, espionage under international law, classically is not considered an armed attack under Article 51, and there's some disagreement, but traditionally not considered a violation of Article 2.4, use of force. So this might be something that either falls below the threshold of a use of force, or if it does reach the use of force, certainly doesn't trigger an armed attack in response. There is some, to be honest, there is some disagreement as to whether espionage hits the use of force. So is that kind of...
Thank you. Eric, just to bring this full circle, since one of the words in the topic of the panel is threat, obviously one way to deal with threats is through deterrence. So I guess what I would ask you is, when we think about deterrence, who are we deterring? Who would a state be deterring? Is it another state? Is it individuals? Is it groups? Does it differ in how you look at those? And what are the forms of deterrence? Is it deterrence when we think of MAD, back from the Cold War, in terms of I'm going to do this to you, and we've reached some impasse? What about accountability as a form of deterrence after the fact, which also has a deterrent effect?
So before I answer that question, if I can just piggyback off what Catherine said, a little over a year ago, President Obama made a speech where he talked about strategic national assets that would have to be protected from cyber attack, or cyber operations, I guess we can say. And he was not talking about military assets. He was talking about intellectual property. He was talking about stuff like that. So I think Catherine's discussion about identifying critical national assets or critical national infrastructure that we may have to start viewing differently is a very powerful argument, and I think one that's getting some traction and that we're probably going to have to deal with, and it may make us reconceptualize. I mean, this topic is about reconceptualizing legal frameworks. That may force us to reconceptualize over time some of the ways that we currently view some of the terms that Mike defined. So deterrence, I think as well, this is one of the ways that we have to reconceptualize or can reconceptualize legal frameworks. Lori mentioned mutually assured destruction, or MAD, the idea back in the nuclear age that we would both us and the then Soviet Union would make tons of missiles with tons of megatons of warheads, and we would point them at each other, and that would be a deterrent, because we would know if one of us launched one missile, then we would, then the other side would launch the rest of them, and it would just be, ultimate destruction of the world. And that was our way of deterring. That was our theory of deterrence in that era. And there were other theories of deterrence as well, but that was kind of the prominent one. And I think that that when we see cyber operations, it opens up to us some potential wider spectrums of deterrence. Now, the first part of your question was about who do we deter, and I think when we think about deterrence, we have to think about full spectrum deterrence. We have to be willing to deter not just states, willing and capable to deter not just states, but also private actors, right? I mean, Symantec estimates that Stuxnet could have been created by 6 to 10 people working 6 months with $1 to $10 million. I mean, when you think about the organizations across the world that may have nefarious ideas, there are lots of them that could gather that kind of asset and create a Stuxnet type thing. So you have to look at deterrence, first of all, as full spectrum. Then I think cyber operations also open up some interesting avenues of deterrence that maybe we haven't taken full cognizance of and applied them appropriately yet in cyber deterrence. We still have this idea of retaliation, right? And ex-Deputy Secretary of Defense Lynn made it clear that the United States is willing to respond to a cyber attack with cyber responses and kinetic responses, and that we do not feel like we have to respond in kind. And we're not limited by the law that we have to respond in kind, but when we retaliate, as one theory of defense, we can certainly retaliate both cyber and with kinetic means. But the other thing that you mentioned, Lori, was maybe what I like to call legal strike back instead of kinetic strike back, right? So one form of deterrence is for us to exercise legal strike back, where once an attack or whatever it is, and I'm going to use the term attack loosely. Mike, don't attack me for using attack loosely. So when I say attack, I'm not meaning attack as the term of art, I'm meaning it as the lay term. So if we're the subject of a cyber bad thing, a cyber attack, then we can respond through the legal process, right? And that's a legal strike back. We can try and prosecute them. There are a number of legal issues, like how do you get passive personality jurisdiction, how do you get an MLAT in place. There are lots of legal issues with that, but that is a form of deterrence. Another one would be security, which is basically the idea that I'm so secure that you can't hurt me or get what you want even if you want to. And I think that cyber gives us some opportunities to do that are not always prevalent in kinetic cases. Now, it also presents some vulnerabilities as the opposite side of that virtual coin, but it is a potential means of cyber deterrence. Maybe another one would be invulnerability. Like, even if you get what you classify as success, it doesn't really hurt me. That kind of builds off this idea of redundancy. The internet is built on redundancy. If we have our cyber system so redundant that even if someone who wants to attack us takes down one system, it doesn't affect our operations, then that's a means of deterrence, right? You can attack me all day, it's not going to hurt me because I got so much redundancy, you're just going to waste your resources and time, you might as well not bother. And another aspect of that is reconstitution. How fast can we reconstitute? If we can reconstitute quickly in a cyber realm, then that acts as a deterrent to people who might want to attack us. Another aspect of deterrence that I think is a little bit unique to cyber is invisibility, right? You can't see me to attack me. You don't know where to find me. You don't know where I am. That's sometimes a little bit easier in kinetic, but in cyber realm, it may be easier to make yourself invisible, or there may be ways to make yourself invisible that would act as a deterrent to some actors. And then the last one I would just mention is interconnection, which is the idea that we are so interconnected by cyber means that attacking me really hurts you. So there's just no point in attacking me anymore. Now, none of these will work on everybody. Some of them will work on nobody, but all of these, I think, present us with some interesting options that we are not yet, I don't think, taking full advantage of.
But I'm going to throw out some issues for all of you to jump in on, and I'm sure we'll have some disagreements here and try to flesh out some issues. The first issue I want to raise for all of you is one that...
Lori, can we respond to...
You want to respond first?
I don't want to be disruptive, but can we respond to what the others have said?
Yeah.
Just for entertainment purposes?
Only if you're entertaining.
Well, we'll try to be entertaining. I want to emphasize, with regard to what Catherine said, I certainly believe you're right, and also Eric. The point I was making is that there are terms which have legal meaning, and we must not forget that in providing legal advice to our political masters or our law students or whoever. However, we must understand that law evolves over time through the practice of states, so long as it's tied to opinio juris. So to the extent that your issues, Gary, arise and states start looking at it differently, Eric the same, then clearly our understanding of the norms will mature. All I'm doing is making a plea for understand where the law is today so you can provide proper advice on whether or not you're in violation of the law, and then your political master can make the determination of whether they wish to violate the law, because after all, international law, customary international law, is made through breach of existing norms. So I certainly agree with that. I also agree absolutely with what Catherine is saying. My point was what does armed attack mean today? And today, the concept of armed attack is I harm people or I break things. That's the concept in law. It's taught everywhere. Emory, even great universities like Texas. However, that will necessarily change. And the point you made about vital national infrastructure, critical national infrastructure, is absolutely right. Because is there anyone in the audience that believes that we're going to take a cyber hit on our critical national infrastructure and not treat that as an armed attack? But the point is that customary understandings and norms are made through practice. They're not made in anticipation of events. So we have to have that, as a matter of law, we have to have that happen, and we have to have that reaction before we can say that is in fact the law. And the classic example was, of course, 9/11, and whether or not non-state actors could conduct armed attacks pursuant to Article 51. Listen, everyone on this panel would have said no until 9/12. And then we would all said, of course, they practice, look.
Well, the ICJ would still say.
Well, the
no.
ICJ,
Yes.
they're trapped in The Hague, they're doing weird things in Amsterdam, or in Hague, who knows. The third point is Eric, be careful when you talk about, because your comments were the most troubling to me.
You're used to that,
But we're, so you know, and so you don't think I'm picking on him, we've been friends for decades, unbeknownst to me why. Anyways, we're the most troubling because you need to understand what the legal implication of what you're saying is. Because if we have deterrence, and I'll mention some of the terms, if we have legal strike back, if we have invulnerability, if we have invisibility, this has legal effect on the principle of self-defense. Because if you have those, what that means is you cannot meet the necessity criterion of the self-defense standard, and it will make a strike back kinetic strike back, or a cyber attack or cyber response that rises to the level of the use of force unlawful. So you know, as we're making these pitches that we have all of these arrows in our quiver, we must understand the legal significance of that pitch. And by arguing legal strike back, you have the effectiveness of legal strike back, because it must be effective. You've just taken kinetic responses or cyber responses rising to the use of force completely off the policymaker's table.
Would you have done that
As a matter of law.
outside the cyber world? If we talk about preparedness in the ordinary world, and we talk about accountability
There's absolutely no
mechanisms,
difference, Lori. It doesn't matter if we're
doesn't
talking
undo
about kinetic or cyber. The necessity criterion, this is Carolyn, the necessity criterion applies. And to the extent that we have we do not need to resort to force in response to an armed attack, we may not. It's not simply that an armed attack occurred. It's that now we meet the criterion: necessity, proportionality, imminency, imminence.
So I use that only for anticipatory self-defense.
Ah,
I
well.
disagree. Because under Caroline, it was only for anticipatory self-defense, not armed attack. So I would say all armed attack, you need to meet two criteria: proportionality and discrimination, but proportionality. But anticipatory self-defense, you have an added legal requirement under the criteria of necessity. But Article 51, armed attack, that necessity, imminence, overwhelming, no time for deliberation or other means, Caroline was not about an actual arms attack.
Carolyn was, you're exactly right. Carolyn was about anticipatory self-defense. Is this okay, the fight? Carolyn, are you
I'll be in the middle.
What I want to know
I'll
is whether you're entertained or not. Listen, Carolyn was about anticipatory self-defense, but that fact has been lost over the last century and a half. And at every law school, even British law schools I can attest to, at every law school in the world, Carolyn is taught has the case or has the situation which represents classic self-defense criterion, including necessity. And the mainstream view is that necessity applies to an armed attack. Even if you're the victim of an armed attack, you may only respond if you meet the necessity criterion, which, as folks hopefully know, the necessity criterion says you may not resort to the use of force if other non-forceful options will work. In other words, an armed attack is not an act of war. By the way, act of war is a term which has no significance in international law. It's New York Times, Washington Post.
Here's the part where I disagree. It's the imminence. So Article 51, your right of self-defense, I believe and argued and taught that there's no time limitation on that. So if you continue to have that right as long as the threat exists, but in anticipatory self-defense with the necessity criteria, the imminence part says, so military necessity is custom, right? That's one of the customary principles.
Military necessity is in bello law.
Yeah, so when you're talking about Article 51,
right?
that I say, okay, it must be proportional, but it does not have, you've already suffered that armed attack. With an anticipatory self-defense strike, you need to have imminence. You have to make an argument that that threat is coming and it's coming now. In armed attack, ongoing armed attacks, so let's say 1998, embassy bombings, we then strike militarily Sudan Pharmaceutical Company and Tora Bora training camps. That was after the fact. The argument was, it wasn't a reprisal. We were suffering ongoing attacks, continuing capabilities, but the threat did not have to be imminent. We didn't have to argue it's coming now, anticipatory self-defense necessity. So I think it's the imminence part that I say you don't necessarily have to make that same time argument when you're going to hit an anticipation.
Yeah.
If you've suffered the
I agree absolutely.
attack
Listen,
and you-
proportionality and necessity apply to all forms of self-defense, period. The imminency applies in anticipation of an attack, and immediacy, which is a similar standard, applies after the attack. Imminency says you may not strike too soon. My interpretation is not that it's temporal, but rather it's last window of opportunity. I've written about this. Immediacy means you may not strike too late. Okay, but so it's the imminency, immediacy that applies only to acts that either have not occurred or that have occurred and are over. But necessity applies across the board. And I mean, Eric, I mean, you are taking necessity off the table. The necessity criterion cannot be met if we start making arguments that we have legal strike back capability or we're invulnerable. That'd be a novel argument in the cyber world.
In the international cybersecurity strategy, the U.S. laid out, I guess, what's the best statement of our deterrence strategy, which is we'll treat cyber attacks as we would attacks, traditional kinetic attacks, and respond as we see appropriate. And that led to the headlines in the Washington Post from the generals saying, we'll put a missile down your smokestack and all that kind of stuff. So I suppose it must have been a considered decision in the United States as far as cyber deterrence goes, to maintain some strategic ambiguity about what we would define as a cyber attack.
Here's some of the concerns that I have with deterrence, not so much on the legal side as to the political consequences of having a deterrence policy, vis-a-vis particularly China. In cyber, you've got a potential arms race that you're egging on. You've got escalation problems, more so in cyber than in kinetic. And also you've got real hardcore attribution problems. You might even be technically savvy at saying, we can pinpoint the computer or the server in which that's going, but to then identify the human behind it. So these three problems in cyber particularly make deterrence, particularly vis-a-vis China, which is the big issue now, problematic. And that might push me into, all right, let's move a little bit away from a deterrence posture to think of other means. And I think Sanders just wrote a book on cyberspace and nuclear out of NDU, and he talks about a different approach than deterrence. But I think it's worth at least looking at all of them, because I think in deterrence and cyber, you got some problems politically.
Well, and one of the other issues with deterrence in cyber is, I mean, it goes back to that the movie with Peter Sellers. Have y'all seen that movie? What's that? Yeah, Dr. Strangelove. No, the movie actually has some really long name, but it's the Dr. Strangelove movie. And there's the point where Peter Sellers, as the president, is talking to the Russian guy, and he's talking about the doomsday device, right, that will respond immediately. And Peter Sellers says, well, what good is the doomsday device if we didn't know about it? So one of the other issues with cyber deterrence is signaling, right? I mean, how do you signal cyber deterrence? Which leads into your point. If you signal that you're invulnerable, then does that mean you have removed necessity from the table? I'm not convinced by your legal strike back that it would remove necessity. I think the fact that you're going to prosecute someone legally doesn't remove necessity, because the legal process would have to take place long after your immediacy had already run. But I think with invulnerability or invisibility or interconnection, I think that's a very good point.
So just to piggyback on some of that, one of the issues that seems to underlie all of what we've talked about already, and several other issues, is attribution and identification. And we've seen this in a lot of the conversations that have taken place over the last 10 years about contemporary warfare, asymmetric warfare, lots of terms that sort of get bandied about these days, where we talk about how can we tell who we're fighting against on the battlefield, to the extent we can find the battlefield. Obviously, that's significantly more challenging in cyber. So what I'd like to throw out to all of you is, what are the consequences of attribution from the tactical level, in terms of who actually can you target in response to some type of cyber operation? What does it mean for neutrality? What does it mean for self-defense? What does it mean for a whole range of these issues that we're talking about, that attribution is a problem? What type of attribution would you need for any of these in order to be able to identify and justify any particular action?
I'll take a shot at that. So I've spent some time working on attribution issues at so the national security policy level, dealing, which is close to the cyber issues with bio. So attribution in biowarfare is just as difficult as it is in cyber, in bio more than chemical, right? So the level, let's back up for a second. So it is interesting that outside of cyber, a lot of people assume that policymakers, when they make a decision to use force or go to war, that they must have a really good high percentage of attribution or certainty about the target. And in reality, having come out of the intelligence community, what I know very well is that there's never 100% certainty. Even in kinetic, where we could, in the nuclear age, where we could identify if someone was going to launch a missile, we could identify from the parts, or the nuclear weapons, the signatures. But even in the Cold War, there were concerns about attribution, because there were concerns as, okay, there were a few times where we weren't sure where certain weapons were, if they would get into the hands of a rogue actor, or even a state official that's gone wild, not with the blessing of the state regime. So on attribution, it is difficult in cyber, but there really isn't perfect attribution anyway when policymakers. So the question is how much certainty to U.S. policymakers, from our perspective, would have to have before authorizing, a use of force or an armed attack in response to a cyber incident against the U.S. And so we've done simulations where we've asked, policymakers, or simulated NSC meetings about what level of certainty would they need and what would that look like before they would authorize something like a serious decision to use force. Here's where I think actually a principle of international law, and Eric mentioned it in his discussion during lunch, maybe not stating it in this international legal phraseology, but the norm of state responsibility, I think, is very helpful in this arena where in cyber you might not have perfect attribution. Where you might, in cyber, as in post 9/11 counterterrorism, the Security Council really did make a significant move in the law in this threshold from a Nicaragua effective control over those agents. So Eric gave an example. Well, if a group, non-state actor, was actually tasked, paid, acting as an agent of the state, you could really hang the responsibility and liability on the state, and therefore use force in that state's sovereignty, in that sovereign territory. Arguably, that's if you're thinking about doing that. After 9/11, you see the Security Council moving away from that threshold of saying, well, you really need to show that the state had effective control over that entity in order to extend the liability to the state. Instead, it said, well, no, we might not be holding to that threshold anymore, that it might be loosened up, less than effective control. So in cyber, this is really an interesting tool, I think, this norm of state responsibility. I have talked and think that it needs to be strengthened, have more agreement among multiple nation states as to this being an effective tool. And I've thought about what are the things you would want to see as a criteria to build this norm of international law, aside from acceptance by multiple states, was that legal, so the international law enforcement cooperation. If you have an incident in the U.S. and we are saying we have we believe that it's, state, Russian state responsibilities behind it, but they're hiding behind this proxy or, hacktivist. So you would first have I think you would want to have certain things laid out that, one, you would make official requests to that state. You would expect that state to therefore go to that server that you're saying you can identify as the last hop on the attack and shut the server down, or at least investigate, maybe arrest people, and actually have people arrested and actually have a legitimate trial take place, and don't just let them walk the next day, but people in jail. You'd want to see these steps being taken, and if they were, then you'd say, okay, state, we're going to let you off the hook because you've taken these steps. And there's precedent for this in international law. The norm of state responsibility is not new. With terrorism and counterterrorism, it really got legs. that, Afghanistan was going to be held responsible. There we had a lot of good connection between the Taliban and al-Qaeda through intelligence. But in cyber, I think we can build upon that, where we don't have to wait for perfect technical and human attribution, but under international law, have this framework where we would offer up to these states that we think are the bad actors, China and Russia and Iran. Here, if you want to be on the good list in cyber states, we expect you to do X, Y, and Z if something is the threat is emanating from your country. And by the way, if you don't do X, Y, and Z, you're going to be the first on our target list, because we've already said that we will respond to cyber militarily, as if in kinetic. So we're going to put you on the top of our list if you're not doing this, as suspected, you are responsible for it.
Can I just ask, so even if a country is on the good list, the time required to submit the mutual legal assistance treaty, to make the request for DOJ to do the coordination, et cetera, is extensive. I mean, it can be months. I mean, on a good day, it's weeks, right? Yeah. So what is the interim measure that the country can do in the interim while they've accepted the fact that they're going to pursue this attribution in a criminal law paradigm?
So I would say, I kind of skip over, I say, okay, that's going to take a long time. I assume you're going to take those steps, but I talk about more of the immediate. What should they be doing? What they should be doing is, when they receive a call from our U.S. policy officials saying, there's a server in your country that we've identified as being, we're not saying it's the beginning of the attack, we're not saying you're behind it, but it is certainly the last place in which the attack came from and damaged us. I would then expect the country, and I would say the U.S. should ask explicitly for them to immediately go and investigate it under their own domestic legal structure. So here's the catch. You also then want to bring a number of states, as many as possible, and it is, not a good situation that under the EU Cybercrime Convention, the worst offenders are not members. Right. China and Russia, so you might want to help them along and first make sure that they have criminal statutes on the books. But even aside from criminal statutes, they have investigative powers. They can at least investigate, and they do have laws that they could apply, criminal laws, against potential offenders in their country. So I would want them to do that immediately. Don't wait for those months and months of negotiation of agreements, and then you say, if you take these steps, this is done in good faith. And what would be really good, which I advocate for, they should be willing to allow the state who's the victim state, their investigators into their country. We will help you investigate. Not stepping on your toes, of course. The Russian law enforcement will lead, we will watch, and we will follow. You say something state secret, okay, we won't look into that little box, but we're gonna, you should not welcome us, but when we ask, you should allow us in to help you in that investigation.
I think that's a good ideal to work toward, but in the short term, I think if we put the shoe on the other foot, maybe it's possible to see some of the challenges with that. And again, cyber is a little different than other forms of military action. But when we talk about, for instance, the actions that took place in the Republic of Georgia or in Estonia, the big, essentially, denial of service attacks, either a big plurality or maybe even the majority of those attacks, for lack of a better term, came from the United States. So the question would be, what would the United States, if we got a call, let's say it was in another country, maybe we get a call from Russia or from Iran that says these sites are acting against you. I don't know that we would ever have the legal structure in place to be able to turn those off, because right now we'd have to go through a pretty extensive legal process to get individual sites turned off. But
so certainly with international law, I agree. Its expectation is reciprocity, right? If the U.S. wants to play this game, we're going to have to be willing to do the same. I do think we have the ability, our laws, we're actually pretty robust in our domestic criminal laws, or at least investigative authorities, right? So I'm saying we investigate, we do our due diligence. I am not advocating that, any particular U.S. government agency should have the legal authority with, a snap of the finger to shut people down, right? But investigate, right? We're talking, the Russians, when we want to make a call, they're saying, oh, well, we don't know. They're not doing anything. We have no control over them. It's not us, the Russian government. That's not acceptable, right? So I think, of course, we would have to be willing to do the same, live up by the same criteria. That's why it's important for us to negotiate that criteria with other countries, and so we all know what we're signing up to. I do think it can help, though, with getting a number of states on board as good actors to start socializing this norm, right? Make it more, international.
I thought Gary's hypothetical was interesting, but it seems to me that the international law there is pretty clear. If your territory is being used to the detriment of another state, you have a legal obligation to put an end to that. Period, stop. That's trail smelter.
Yeah.
That's the basic law. Now, in the event you cannot, and by the way, the fact that your domestic legal regulations don't allow you to do it is not an excuse for your failure to do that. It doesn't get you, it's not a get-out-of-jail-free card. Now, in the event that you do not comply with this international legal obligation, this allows the other state to take whatever measures are necessary to put an end to the illegal activity that is occurring, or the harmful activity that's occurring on your territory. And remember, this is our legal justification, for example, to go into Pakistan and kill people. So I think this is one we want to hold dear. So in your hypothetical, the Russians would have every legal right to take measures on U.S. territory in violation of our sovereignty to put an end to those harmful activities emanating from or through the United States. I also wanted to go back to your question, Lori, on attribution and kind of tease apart the international legal issues. There are really two issues when you're talking about attribution, international legal issues. The first is, how much evidence do I need? Because all the technical experts, the wireheads they're called, they tell me it's very difficult sometimes to track back and determine where it's coming from. What's the legal standard? The legal standard is pretty clear. The legal standard is you have to act as a reasonable actor would in same or similar circumstances. We in the United States should know that standard well because it's how we justify our invasion of Iraq in the face of claims that the Iraqis never had the bad stuff and so forth. We say, listen, yeah, but at the time we made a reasonable call. We know it was reasonable because both the French and the Germans, who were then president, they voted for 1244, which condemned the Iraqis for doing all this stuff, which it turned out they didn't do. So the first question is attribution. You must act as a reasonable actor would in same or similar circumstances, but you don't need to get it right. Okay, what's reasonable? The second question with regard to attribution is who can I, if an act occurs, when can I attribute it to a state? That's the second question. And Catherine's exactly right. The articles of this 1 point, Catherine, you're still at 0. Catherine's exactly right. The law on this is relatively clear as well because it's set forth in the International Law Commission's Articles of State Responsibility, which most people would deem to be reflective of customary international law. However, what we must remember with regard to the Articles of State Responsibility is they don't envision a response that rises to the level of a use of force. That's ruled out. So in order to get to a use of force response with regard to attribution, then we have to resort to the Nicaragua case. And again, Catherine, who's now up 2 points on you guys, Catherine's exactly right. This standard is in flux. Because remember, the International Court of Justice adopted the effective control test, but in the Tadic case, in the ITCY, they, in a somewhat different situation, adopted a different test, overall control. And I think most people would say that the ICTY in the 90s got it right, has distinct from Nicaragua. And why is that important? Because that answers the question of when can you respond with a use of force to an action conducted by non-state actors and respond against the state sponsor. Now, whether we want to go to the level of the U.S. national security strategies of 2002 and 2006, which talks about sanctuary, there's no legal basis for this whatsoever. There's no legal basis to suggest that you can attribute the acts of a non-state actor acting in foreign territory to that state. No legal basis. However, remember my earlier comments, watch this space, because the evolution of state practice may move us to that point. The national security strategy, to the extent it says that we can strike back, is wrong as a matter of law today. But it is an expression, to some extent, of opinio juris. And if other states take up that call, then it will in fact become a new legal standard supplanting the Tadich overall control test, such that if you merely allow hacktivists to operate from your territory, then the fight's on with you.
I'll throw out one more question. Actually, I'll be two wrapped into one, and then we'll open it up to questions from the audience. I want to bring this down many levels of altitude and throw out a question of what are the consequences for how we talk about cyber and the law of war in particular for training, for rules of engagement. So we come down many, many levels, not just from what is the law and how do we figure out these broad legal concepts, but what are these disputes or what do these uncertainties mean in terms of how we train? You know, if we have more and more, whether, you know, military forces who are engaging in cyber ops, obviously you're not going to, it's not the same nature that you would kinetic operations, but still, if they have to comply with the law of war in doing it, which they would, what is the essence of the training that would have to go on? What would be the rules of engagement that would govern that? And just to use my moderator's privilege to make two questions into one, I'm curious, I guess, Mike, but others, we talk about the term attack in the law of war in AP1. What about constant care, right? The additional protocol 1 requires that all militaries use constant care in all military operations. When is cyber a military operation? That's clearly not an attack, right? That's a much broader category. So how do we define constant care in cyber? So those are not related, but I put them together just because I could.
That ROE question's got to be yours.
Yeah, I don't think there's a huge change in the protocols for training because of cyber, and the reason is that, again, unlike kinetic warfare, cyber typically is done and will continue to be done from a few centralized locations. It's not really distributed. Everybody doesn't have a cyber rifle out on the battlefield.
Could that happen someday?
I guess in theory, I don't think it will.
Guys lined up at computers, right? Launching
well,
codes.
I think maybe they will be, but in a central location, because again, geography has very little relevance when it comes to cyber, and you can be anywhere on the planet, and within milliseconds, the effect happens on the other side of the planet. So it doesn't really matter where they sit. It makes more sense to keep them centralized in a few locations. So I think you can train a small cadre of folks, and really the training. Of course, we need technical experts, so outside of the law, and they don't necessarily need. They need a light coding of ROE training and all that, but they're sitting there with adult supervision all the time. So we're going to need to train up a cadre.
Unlike us on the panel.
That's right. We'll need to train up a cadre of cyber lawyers to keep the flow going, but we're kind of in the process of that now.
So here's my, just whatever it's worth, 2 cents on the training. One of the concerns that I've seen or I worry about in terms of, and it's related to the legal issues that come up, is the intelligence versus the military operations. And why am I informed about this in the way that I'm concerned about the training is, and I'll draw from an example where I first saw it, and there are people much smarter than me that drew this lesson learned. It was the investigation of Abu Ghraib that was done by the military, one of the military investigations. This one was done by 3 generals. I think there was like a 4, 3, and a 2-star. It was called the Kern-Jones-Fay Report. It may still be classified, I'm not sure. But what I remember, and it struck me as very important at the time, when they were investigating what went wrong in the prison in Abu Ghraib and why it happened, why there were young military officers, intel officers, and police officers in the military that did things that were surprising that the military would do that was not in line with the Geneva Conventions that they've been trained on. One of the lessons that they drew in that report, and has always stuck with me, is that they said that by commingling the different organizations, this was a military prison, and there were military personnel in charge of that prison, but within that prison, there were other government agencies, AKA, CIA, if you will, but civilian individuals that were walking around, and the young military folks that were in charge of the interrogations and linguists and the police that were involved in the interrogation rooms were under the impression that those civilians were in charge. And Kopinski, who was the military officer, she was in charge of that prison. She was reprimanded and relieved, or something, she was punished. But I remember her saying, testifying that she was told that this one wing of the prison was just not under her authority, and therefore, I mean, so people wonder, that's, if you're in the military, I asked my husband who went to West Point, like, is that, can you do that in the military? And he's like, no, that's your responsibility. That's why they have chain of command. You don't just like relieve your responsibility and say, oh, it's somebody else's, particularly civilians. So the Kern-Jones-Fay report said by commingling these people, it was not a good way to go about operations. You took people who were the military trained in Geneva, and you put them with civilians that were operating under different legal authorities. One might say in certain places, CIA under covert action authority, presidentially authorized. And so Kern-Jones-Fay said, and this is what you get. You get problems, you get misunderstanding, you get the military all of a sudden operating outside of the line of what they were trained on. The first question that was asked of these, 18, 19-year-old interrogators was, and it was probably CYA by the lawyers, did you receive your Geneva training? And of course, the interrogators were like, yes, I did sit in that briefing. I know my Geneva training, because the investigators were trying to figure out why then did you violate some of the principles. In cyber, I am concerned about the similar thing, about military personnel being trained on the laws of war, that it's second nature to them, and commingling that with intelligence officers who are operating under different legal authorities. And so on, and covert action, in academic circles, intellectual circles, if you talk to any practitioners and you ask, well, does covert action violate international law? So George Tenet would always say to me, well, of course, Catherine, it does. And I'd be like, well, okay, as a lawyer, let me think about that. Let's talk about that. Maybe not all covert action violates international law, and maybe not all of it violates all of international law, maybe just certain parts of it. But the military, you put them in those circumstances, maybe not a recipe for success. You want the military to follow international law and the laws of war. So I think the training, and not only the training, but how you deal with the different workforces under the law, both international law, but the domestic, Title 50, Title 10 authorities, which are different, is really important. I don't think that's been, I don't think it's been thoroughly addressed. But I think some might think it has been. I'd like to really understand more as to how it's been addressed.
Well, I guess since everyone seems to be dodging it, I'll take the constant care question, which is a very technical IHL question. I assume Lori is writing an article and could not find the answer herself, so she thought she would seize this opportunity to find out what it means. What Lori is referring to is Article 57 of the Additional Protocol 1, which our country recognizes in great part, not entirely, but in great part is reflective of customary law. And I will read it to you. It says, Article 51:1, in the conduct of military operations, constant care shall be taken to spare the civilian population, civilians, and civilian objects. The reason she's interested is because then Article 57 goes on to talk exclusively about attacks. And so she's wondering if there's a distinction, and in fact there is. The reason the rest of the article talks about attacks is because they are talking about collateral damage. You must take care, you must choose methods and means of warfare, you must choose your targets in order to avoid harm to civilians, physical harm to civilians or objects. The constant care provision is a chapeau provision which says, and oh, by the way, be careful generally. The care is not analogous to the legal standard of taking precautions in attack. And the reason is the precautions in attack requirement only kicks in if you have something that qualifies as collateral damage as a matter of law. And that's injury or death of an individual or damage or destruction of a civilian object. The constant care is for things like be aware that when you're conducting military operations, that may in fact have an impact on the civilian population. So if you're going across repeatedly the only bridge to a village, it's going to be hard, for example, for emergency vehicles to pass. It's going to be hard for medical supplies to come in and so forth. It's very important in the cyber context, because lots of cyber things that you might do, lots, will have an impact on the civilian population without causing what would be collateral damage as a matter of law. So it's basically telling the folks at U.S. Cybercom and places like that, the mere fact that you're conducting an operation that does not physically harm someone or something which is protected under humanitarian law does not mean, you know, that's the end of your analysis. What you must still do is attempt to fashion your operation that in a way that, even though it's not unlawful if it affects the civilian population, but will, to the extent possible, minimize that impact. But Gary, you must have known that.
Clearly.
Why don't we open it up to questions? We have about 10 minutes. You guys want to come to the microphones in the aisles? Have we put you all to sleep?
To do that.
This must be the Emory Law School plan. If I'm correct, this is the president of the International Law Society who is trying to salvage the question and answer period.
Not at all, Professor. Nice to see you again. Anand Shah from...
President of the International Law Society.
Exactly. No, but my question is, and going off this idea at the end about dual-use technology, you know, where, I mean, I've seen a lot of different statistics. You know, the internet carries 80% of, you know, it's 80% civilian, 20% military, something to that extent. I mean, you can see different statistics on that. But the fact that it's, you know, almost everything is dual use, how do you square that away with, you know, what you were saying in the sense of, you know, having concern towards attacking civilians or affecting civilians when all you want to do is, you know, attack military objects. And how do you square that with the role of information sharing, which I think is emerging as kind of the, you know, the big ticket in a lot of the domestic regimes that are popping up around the world. I know that's largely a big issue of our pending, you know, legislation here in the U.S., as it is also in different countries as well. And this is kind of open to everybody.
Well, I mean, Anand, thanks for your question. It's very good. It proves the wisdom of Emory of making you the president of the International Law Society. Anand and I are old friends. He worked on a project of mine some years ago. Listen, if something is used 1% for military purposes and 99% for civilian purposes, then as a matter of law, it qualifies as a military objective pursuant to Article 52 of the additional protocol and for Americans, customary international law. This is without question. It's without question. Once you get there, once you cross the threshold of it being qualifying as a military objective, then you have two more hurdles to get over. The first of these hurdles is the hurdle that Professor Blank was talking about, and that's precautions and attack. Precautions and attack says that you must conduct the attack on that 1% in the way that minimizes collateral damage, in other words, physical harm to things or people. And so you pick that method of attack or that means of attack, whether it's cyber or bombs, in a way that will minimize the harm to the civilian population. There's a very good example. It is an attack during Operation Allied Force in 1999 against the Serb radio television station. It was attacked, and in the process, some folks were killed in the attack. There's a big question on whether it qualified as a military objective. I don't think it did. But let's assume for the sake of argument that it qualified as a military objective and we had cyber available. Well, since what we really wanted to do was to shut down transmissions, offending transmissions, instead of bombing it, we would have been obligated, as a matter of law, to conduct cyber operations against the radio television station because the harm to civilians and civilian objects would have been less. That's your second step. You then move to the third step, which is proportionality, not proportionality in the sense that Catherine was talking about earlier in the ad bellum, but in the in bello proportionality, which says that you may not conduct an attack against a military objective if the expected collateral damage is excessive relative to the anticipated military advantage that you're likely to get. So your last step is saying, knowing what I know now, is it justifiable to cause that human harm? Now, with regard to information sharing, that's irrelevant, except except for the circumstance of neutrality. And an unanswered question is, because we're all connected, what happens if I conduct an attack during an armed conflict against something that qualifies as a military objective, taking all my precautions and attack? It is proportional relative to the harm that will be caused there, but it also generates harm in another country. Well, clearly the harm in another country is factored into your equation, but the question is, can you cause harm in neutral territory? I'm not sure I know the answer to that question. That's a very complex question that really surfaces almost only in the cyber context, and I don't know the answer.
On that, one of the difficulties also in cyber is even anticipating that what the consequences will be. You might not always know that if you do an act A in state A, that it's going to affect state B. You might not actually have the ability to know with a lot of certainty what the consequences of your act will be. So that is hard to square with the legal requirements of minimizing collateral damage and discrimination. I think that was
This is
a takedown
this
of the
is a
website.
fascinating concept, because if it causes effects in neutral territory, and you did not anticipate those effects, and your failure to anticipate was reasonable, then there's no legal issue. This is the classic case of, I'm in my cosmic all-weather fighter bomber, I release a bomb, and my bomb goes ballistic, it loses and it zims across the border and blows up. This is not an issue. This is not a violation of neutrality. No one would suggest it is. The question is, what happens when you do your analysis and we're all interconnected, and it will have an effect in neutral territory? Is it good enough to simply factor that effect into the proportionality analysis? So where's the interplay of the law of neutrality and another body of law, international humanitarian law, law of armed conflict? Great question. Great question.
In application, they're maybe even more complicated because the whole geography thing comes in again, and we sort of blithely say it'll have an effect in another country. But earlier we talked about in the combat zone, for instance, now in Afghanistan, if we have an effect in Afghanistan, it's not really controversial. The problem is if you put yourself in a position of somebody who's fighting against us in Afghanistan and think where you would want to put your cyber material, probably Afghanistan doesn't jump to your mind, because there's not a whole lot of infrastructure in Afghanistan. And we have this enormous cloud now that spans the globe where you can store information and use for communications across the globe. So it gets much more difficult when you talk about having the effect in Afghanistan, but the information might be stored at some random location in the Amazon cloud or the Google cloud or whatever it is, and it might be stored somewhere where they don't even know where it is, and we might be able to find out. I also feel like I ought to address the issue of, we often hear that about the possibility of unanticipated effects. We at least think that we're really good at anticipating the effects, and I think the history bears that out, and really wouldn't even cross our minds to do something where we didn't think we had 100%, as close as you can get to 100% certainty in this world as to what the effect would be. That's not to say, whoever knows, even in a kinetic operation, whether or not you drop a bridge and somebody's so distraught over it that they jump off a building or whatever. We can't anticipate it to that extent, obviously. But as far as, the first thing that comes to that seems to jump to people's minds when we talk about any kind of cyber operation is, well, what about, oh my gosh, how do you know you're not going to turn off the power to the hospital and all the babies and incubators are going to expire? And that's just so far removed from it's just it's really not even a factor. But it seems to be the first thing that policy people think about because there's uncertainty about the way cyber works.
But, Gary, that's true with regard to U.S. Cybercom, but it's not necessarily accurate with regard to a non-state actor that might conduct such an operation. And remember, if we're involved in an armed conflict, that means the non-state actor may very well have committed a war crime.
Oh, true, yeah.
So
the ones we've been fighting recently don't care about the law of war anyway, so.
That's true. Good point.
I do agree on the hospitals, for instance. Pretty easy to identify and stay away from. But when I talk about hard to anticipate certain consequences, an example that was in the press, where DOD and CIA got into a disagreement over a website that was a jihadist website, run as a joint intelligence operation, CIA with the Saudis. The Secretary of Defense, Gates at the time, we had information that it was being used by jihadists, and it was basically facilitating recruiting and logistics to bring the jihadists into Iraq, ultimately killing, being part of killing of American soldiers. Gates wanted it taken down as a website. The intelligence community, or CIA in particular, said, no, it's a joint intelligence operation. We're collecting good intel on these guys. So Gates prevailed, and it was taken down. What was, at least from the public reports and discussions of it by some people in and out of the government, was that there were unforeseen consequences when they took the website down. Of course, they cleared it with the Saudis, that, okay, we're going to take this website down, which is physically in your country. But then it also took down websites in a neutral, and as it was later revealed, a neutral country, Germany, which didn't make them very happy. And worse, if you want to comply with U.S. domestic law, it also affected private companies in the state of Texas.
Yeah, and I really, really wish I could say more about that, but you have accurately summarized Ellen Nakashima's article in the
so
Washington
as
Post,
it's-
and that's all I
yeah.
can say.
So if we believe some of it, not all of it, right? I think
And that
hospitals.
would be a good position to have, too.
Yeah, so even
believe
some,
of it.
just say, take some of that.
Yeah.
There are going to be occasions where we might not always be able to anticipate affecting a third state, or exactly how it'll affect it. Because we don't have perfect information about how a state utilizes their infrastructure. Or like if in Russia, like Estonia might only have so many people in their government hooked up on the internet. Well, Russia, if they did something in response, who knows, there might be quite a few, a lot more of their government might be hooked up to it. So, maybe, I'm making this up, 1,000 people lose email access in Estonia. But then when Estonia responds to Russia, it wipes out, because of the number of Russian government officials, it wipes out 20,000, high officials or people important that need email. So I don't think we have perfect information on consequences. I think we were a little better with kinetic. You can measure, okay, if we drop this kind of bomb, we know it's going to kill, average this many people, radiation will last so many years, and now let's try to figure this out as to whether we want to do this. With cyber, if we don't have perfect attribution, I'm not sure we have, really good consequential.
Yeah, I have to respectfully disagree. Having done kinetic targeting and cyber targeting, I think we have a lot better information in cyber than we did in kinetic.
That's good news.
And the
then.
consequences are much
For the law.
are much worse for the collateral casualties in kinetic than losing email. But
We have-
Oh, yeah, deaths versus.
yeah, you can.
I think we have time for one more question. Professor Amon?
Yes, hi, Diane Amon. I'm an international law professor at the University of Georgia, and I just want to thank you for a really fascinating conversation. I taught the laws of war last semester and discovered on the very first day that there were people in the class who came solely to learn about cyber warfare. One of them admitted that he came to be able to play his cyber warfare video game better because he figured if he knew the rules of the laws of war, he would have one up on the other players. This was a bit of a challenge for me because this was not an area that I was familiar with, and we did get to it at the end. I felt that we need to learn the entire structure of the laws of war before we could get to what for them was the sexy stuff. And even after working through it, I was not sure if it mattered that the technology of warfare has changed. And I'm still at the same question after hearing your panel. It seems to me that the legal frameworks out there are adequate to contain and regulate cyber warfare. But what I'm hearing is we don't like the conclusions that takes us to. Mike's example about neutrality. My understanding about the humanitarian impulse behind IHL is if there's that risk, you don't do it. But I think what we haven't really forthrightly stated here is that that's what at least the United States military and its allies in NATO are not comfortable with being the bottom line all the time. And so it seems to me the problem is not whether cyber is so different we have to change things. Maybe the real issue is, are we going to change things because we want more flexibility in cyber and perhaps are less concerned about some of the effects than we would be if it were a field of civilians dead after a massacre? And that's part of what I hear with Mike saying, I can tell you what the law is today, I can't tell you what custom will be 10 years from now. And I think that's the world that we've been in since September 12th of 2001.
Quick response from everybody.
So I think, I mean, I sympathize with your, I guess I'm not in your camp in that I believe there really is things substantially different about cyber. And I think actually about other technologies in which we are starting to go. I think principles, bedrock principles of the law of war we'll have to rethink how we perceive them. And it may be that we, that it is, as you say, just a convenient decision that we don't think they apply because it's not convenient to have them apply. But as Mike mentioned at the first, I mean, the law is customary international law, and that would be the same with customs about the law of war would be amended in the breach, and then we would come up with a new custom based on state practice and opinio juris. But I think principles like distinction and discrimination in areas of cyber and other areas, I think time will push our current understandings of what those principles mean. And it may be that we'll still use the same word, distinction and discrimination, but it will play out in application vastly different than it did in, you know, the 1940s or the 2000s. And I think there are a number of examples like that.
Actually, I agree with you, Diane. I think that it does present some new issues. It presents a new issue, or issues we haven't thought about. It certainly presents a new issue with regard to use of force. But then again, so did arming guerrillas until Nicaragua. No one would have expected that to be a use of force, and the International Court of Justice, of course, said it was. It also presents a new issue with regard to the definition of attack, which is central to the current debate. But in great part, I think, you know, we're involved in this project. We've been doing it for 3 years, and in great part, it's certainly with regard to IHL. Certainly with regard to IHL. We tend to all agree, hey, the old law works. It works. It's just a question of figuring out how it works. I think your sense is the right sense. I think the problem is that as we apply the old law, I mean, you've heard me over and over again say, listen, what's the legal standard? As we apply the old law, we're kind of uncomfortable with some of the results. We don't like them. And it's just going to take time to shake out where we're going with this developing interpretation, much like it has taken a little time to shake out whether or not we want to treat attacks by non-state actors as an armed attack under Article 51. Where that eventually comes out, I don't know, but I think the most important thing to remember is what you see depends on where you stand. And so it depends on whether or not you're a state with capability, or you're a state that is very vulnerable to these sorts of operations. Are you a state which would like to leverage these capabilities, perhaps because you can't afford a real military, but you certainly can afford some MIT or University of Georgia hacker to engage? Or are you a state that's highly vulnerable and you want to protect your secrets and so forth? The problem is countries like ours, because we are, in fact, to some extent vulnerable, because we're wired in. But to the same extent, we are, by a factor of 8 gazillion, the most powerful state in terms of offensive capabilities. So where do we want to come out? I think we're conflicted. I think we don't know. That's why the policymakers are struggling, because they don't know what they want the answer to be. Yeah, I want to do it to you, but I don't want you to do it to me. And that's not the way international humanitarian law works. As you know, there's the principle of reciprocity, which pervades the entire body of law. So, I mean, really, watch this space. I think it'll be a fascinating decade. I think a lot of these will be answered in the next decade. As to the prospect of answer through treaty law, forget it. Not in 1,000 years. The sides are too far apart. If we can't agree in the international community on what direct participation hostilities is, we're sure as heck not going to agree on all these cyber issues. So forget that. That'll never happen.
Just one short one. I don't disagree that we probably have the basic framework that can apply in cyber. The devil's always in the details, and that's the tough part. But the frustrating part to some of us who do cyber operations is that the promise of cyber was a more humane method of warfare. That is, fewer people die, fewer things are destroyed, national interest can be pursued through non-kinetic means. Because of all the misunderstanding and maybe the over-application of law and equating it exactly to kinetic warfare, we've ended up with situations already where it's just simpler to use the kinetic option. It's just easier to drop a bomb than it is to use cyber to effectuate your desires. So that, I think, is an important thing to remember. It's just not the same thing. And finally, although I think DoD is doing a better job, and we're trying to do a better job at doing this, there are just a lot of things that happen below the public radar that I would say suggest that there are international norms and custom and practices developing. It's just that
But
it's not.
they can't mature into law until they
Right.
become public. That's the problem.
I agree.
As a matter of law, they can't.
I agree, but nations are still practicing.
When they mature, it will happen that quick because everybody's doing it.
Yeah, it's there. So at some point, it'll come out, and then we'll have something better to base it on, but that's what we have now.
Well, so for instance, Stuxnet, that's practice.
Right, exactly.
That is,
Came
it's
Yeah.
public, it's
That's right.
practice, it changed this whole arena.
Mm-hmm.
And some haven't thought we may see more of that. It certainly changed things, and it's very public.
Did someone tell you who did it?
No, that doesn't matter.
I was just
Well,
wondering.
It doesn't matter.
Eventually, we will know, and then state practice will have changed.
Yeah.
Okay, well, on that note, I'd like to thank our panelists for a great discussion this afternoon, and thank all of you for coming out today.
A couple concluding remarks before everyone jumps ship. Before we close for the day, I want to just give another round of applause to all our panelists today and our keynote speaker. I think the discussion was wonderful. He may have, no, he's here. I want to also thank Abe Canoff, who started out the day, but I don't think has gotten enough public appreciation, so here we go. With Rachel Kaufman, he's worked tirelessly over the last year to put together this day. I think it's been phenomenal. He's truly the mastermind of the event, and the Law Review owes him a great debt. So I think we owe him a round of applause. I want to re-thank the Center for International and Comparative Law for their financial and logistical support, especially Professor An-Naim and Edie Bridges. I want to thank Professor Lori Blank, whose expertise in the law of war and her connections in this area have allowed this symposium to take shape. I want to acknowledge another co-sponsor of this event, the Lieber Society for the Law of Armed Conflict. They helped get the word out about this symposium and have done much to ensure our success. Thank you, Dick Jackson, for being here. It's an honor to have you here. Thank you, everyone that was involved in this symposium, particularly the staff of EILR. The two L's in particular work tirelessly and largely without complaint. And I'm in constant admiration for all that you do for the journal. And I think it's been a wonderful and productive day, and thank you very much for attending.